Good evening. This is Laws 12067. This is environmental law. We are into week 4. Tonight we're covering international environmental law and federal governance. So when we talk about legislation for environmental law, we are essentially doing so at 4 levels: international, Commonwealth, state and council. International law is important in environmental law because it's from international law that many of the key concepts come about. It is essentially a form of public international law. One of the difficulties with international law generally is that enforcement is not strong. There are some things that can be done through international conventions and treaties. There is the International Court of Justice, but there are some inherent difficulties. Now, if we have any questions, please feel free to unmute your microphone or ask through the chat facility. Because we only have a small cohort, I'm not going to ask too many questions, but at this stage I'd be looking to see if people could tell me the main conferences that have a bearing on international law. I'd probably think about the Stockholm Conference in 1972 and the Rio Conference in 1992. So have a look at those, undertake some reading about those conferences. I mentioned briefly the International Court of Justice. I'm going to attempt to share my screen so you can look at the website. Like other courts, it has up-to-date information about the latest decisions, practice directions, practice information, press releases, and fascinating to go and see the International Court of Justice if you're ever in the area of The Hague in the Netherlands. So I'll leave you to consider that. The focal point of international law is 4 sources. Again, I won't pick on you to say what are those 4 sources, but let's go through them. Firstly, there's treaties. Then we have international custom. Third is general principles of law, and the fourth are subsidiary sources, such as decisions of courts and tribunals. And this is interesting, in that subsidiary source, writings of jurists is regarded on the same level as decisions of courts and tribunals in terms of its categorization, probably not so much as in terms of influence. I say that's interesting because it's in contrast to what we have in Australia, where the primary sources of our law, of course, are legislation and case law. Writing of jurists is regarded as a secondary source, whereas in the international sphere, decisions of courts, tribunals, and writings of jurists all form part of the 4th source of our law, which is subsidiary sources. So treaties, customs, general principles of law, and then the subsidiary sources are the 4 sources of international law. Treaties, well, you'll read about those from time to time. There was a great deal of interest in treaties following the conventions that I've mentioned in particular through 72, 92. So through the 80s and the 90s, we had a lot of material coming through at an international level, which filtered into the Commonwealth sphere. Now, when Australia signs an international treaty, it is really just an intention to be bound. In Australia, it is the government, not Parliament, that makes a decision to ratify the treaty and does so after consultation with the states. So the law in Australia is actually changed when the legislation is passed, which gives effect to the commitment made by the signature to the international treaty. You can argue it. If Australia is a signatory to a treaty and you're arguing a position, then even though it may not have been created into legislation, you can still advance it as something for a court or tribunal to consider. So that's treaties, which is really at the highest echelon. Below that, we have customary law. It's the 2nd source of law, and it's essentially what is generally accepted international practice on a particular matter. That's simply what we mean by customary law. The 3rd are general principles of law. To give an example on that, have a look at the Stockholm Declaration. Article number 21, Stockholm from 72, and Principle number 2 of the Rio Declaration from 92, which basically provide for the same thing. And that is a declaration that a state, meaning a country, shall not cause environmental damage to neighbouring states. So that principle of neighbourliness, if I can use that term, in Article 74 of the UN Charter relates to social and economic and commercial matters. So you can see that when a treaty comes into existence, the states will become signatories if they choose to do so. The law then may be changed by Parliament down the track. It doesn't have to be, but it may be. And we have the UN, which will act upon those treaties to create charters for themselves also. And then there are the subsidiary sources of law, as mentioned, the decisions of courts, tribunals, and the writings of others. All right, no questions at this stage? If not, I'll continue. I mentioned that compliance is a concern. Oddly, when it comes to compliance issues, the starting point is really just negotiations. Dispute resolution has a role to play. Those of you who have studied dispute resolution will know that it's a course that I take, or unit I take at this university. And it's no different at an international level. We still talk about mediation or conciliation. But states, as in governments, will enter into that process. Unfortunately, because the centralised enforcement procedures is limited in its scope, states themselves often have to enforce those international laws. The International Court of Justice is the principal judicial arm of the United Nations, and that is at The Hague, but ensuring compliance still remains difficult. And I mentioned earlier that Australian law does not change until it is given, has a domestic effect, until a domestic law is passed. I should have mentioned that a case as authority for that proposition is the Minister for Immigration and Ethnic Affairs against TEOH. All right, so we have a situation where treaties are created, signed, Australia becomes a signatory to the treaty. What sort of things have been created that become part of our law as they filter down? Well, as you might expect, treaties are quite grand documents which provide broad structures. There's not a lot of mechanics involved in a treaty. You know, for example, a declaration that states will not cause environmental harm to each other is very broad in its application. So what are some of the important broad principles that started their lives in treaties which have now become central parts of our environmental law? If I had a whole bunch of people, I'd be asking for volunteers, but I won't tonight. One is the precautionary principle. Another is the principle about intergenerational equity. You'll see references to the precautionary principle often. It's very important. And if you're looking for an argument in relation to environmental law, promoting something about the precautionary principle is always a good way to go. Now, I take it we know what the precautionary principle is. If you're watching this presentation later, stop now and make sure you go and have a look. What you'll find is that the threat of serious or irreversible environmental damage, lack of full scientific certainty, should not be used as a reason for postponing measures to prevent environmental degradation. In other words, decision makers have to take into account the fact that where there is scientific uncertainty, the government may be answerable to the international community for its conduct and therefore must proceed cautiously. Intergenerational equity means that the present generation has a responsibility to ensure for the health, diversity and productivity of the environment, and to have those things maintained for the benefit of future generations. Again, these are great general arguments that you can run in a whole range of answers to environmental law questions or arguments before a court or tribunal in relation to an environmental law issue. That's pretty much all I'm going to say about international law. I hope what you've taken from that tonight is that it's still a developing area. We do have the Association of States. We do have a hierarchy of sources of law in international law. We do have some means of resolving environmental law disputes, partly through the International Court of Justice in The Hague and partly through negotiation and ADR. But probably the most important aspect of international law is the manner in which principles of great importance ultimately, for the most part, filter their way down into our domestic law. Not surprisingly, the starting point for that domestic law is usually the Commonwealth. Now, can you see what the dilemma is? I'm talking about environmental law filtering its way through treaties for the Commonwealth to make laws about the environment. Section 51 of the Constitution doesn't provide the Commonwealth with power to make laws about the environment. So we have a conundrum. And that conundrum was resolved largely as a result of a spate of High Court decisions in the 80s. From an environmental perspective, the key decision of the High Court was the Tasmanian Dam case. The citation is Commonwealth against Tasmania, 1983, 158 CLR 1. And what that did was have a resolution by the High Court in relation to circumstances where the Commonwealth government sought to enact laws which were ostensibly environmental in nature in circumstances where the states, in this case Tasmania, said you don't have power to do that. So what did the Commonwealth do in order to overcome and ultimately succeed in the High Court? What did it do to overcome its lack of direct power to make environmental law? Well, it relied on other powers that it did have. And the High Court accepted that. So, for example, in the Commonwealth against Tasmania, given that it was creating laws at a Commonwealth level that gave effect to treaty obligations, the High Court was prepared to accept an argument by the Commonwealth that it made the law domestically via its external affairs power, which it does have constitutional power to make. So we had other cases in the 80s, Commonwealth and states arguing in the High Court until eventually in the early 1990s, the heads of government, the Commonwealth, the states, the territories, representatives of local government, I mentioned there are 4 tiers here. So we had those 4 tiers, represented the heads of government of those Commonwealth states, local government, meet at a special Premier's conference to consider environmental law issues, international law issues. And the international agreement, the Intergovernmental Agreement on the Environment in 1992 came into being. I'm just reading some comments about the way in which that case that I mentioned in the High Court had real impact. Okay, so the I've got international law on my brain. The Intergovernmental Agreement on the Environment in 1992 came about as a result of the COAG meetings. And have a look at that agreement. I won't show it on the screen, but it provides in the preamble to the document the purpose of the agreement. And essentially I could summarize it this way. COAG and the International Agreement on the Environment resulted in the stakeholders saying, let's cooperate rather than fight. Let's define what it is that we do. Let's try to reduce the number of disputes in the High Court. And if we do all those things, it will create greater certainty of government for people that actually are affected by these things. People in business, people that represent the environment, councillors, etc. Ultimately, the aim of COAG and the agreement on the environment was the result of better environmental protection. So there's clear statements there about what the Commonwealth will do, what the states will do, how this will be affected administratively, what are the actual systems that are put in place to allow for things to progress in an orderly and properly constituted manner. So we have a different approach. The lawmaking power of the Commonwealth as a result of that agreement essentially grew. We had the Murphy-Oars decision back in 1976, and that was one of the forerunners to this issue about making laws in the environment. And the Commonwealth has progressively relied on different powers: trade and commerce, financial affairs powers, fisheries, corporations, external affairs, or the acquisitions power. Now, the acquisitions power is the famous power which was in the castle, acquiring property on just terms. So that's section 51, subsection 31 of the Constitution. That is the power of the Commonwealth to acquire property on just terms. And you'll see in the text material, and this is a bit of a favourite of mine when it comes to exam questions, some commentary about, it is a good movie, some commentary about what it means for the Commonwealth to acquire property on just terms in an environmental law perspective or context. So if you want to do some reading and have some, you could even have an exam question pre-prepared almost for this. So if you're answering a question about the Commonwealth's role in acquiring property in just terms, you'd have to talk about the Constitution, you'd have to talk about section 51, subsection 31. We've just mentioned that. You'd then have to say that the action taken by the Commonwealth must have an effect on property rights, because the power is to compensate if it acquires property on just terms. So what we see is an argument or series of arguments about what do we mean by property. Have a look at mutual pools against the Commonwealth from 1994 CLR 155. Property essentially, said the High Court, was there must be at least some identifiable benefit or advantage. In other words, if you just simply sterilise or deprive or modify, that's not enough. There has to be something more than a restriction for it to entitle compensation to be paid. Likewise, if you extinguish a permissive right, that's generally not sufficient to allow for a claim for compensation. So mutual pools against the Commonwealth is a good starting point when we talk about the case law. And I've given a few hints here. You need to understand the difference between a property right and a permissive right. Or if we had 20 people online, I'd be saying, okay, what's an example of a permissive right? And someone would say a license is a permissive right. So a permissive license doesn't have security attached to it. It's generally a license by its definition is normally revocable at any time. So if someone takes away a license, should the Commonwealth compensate that? From a political point of view, we often see that the governments do, in terms of fisheries or pharmacies or taxi licenses, etc. But that's not necessarily a legal obligation when we look at the constitutional definitions. So if you're talking about answering a question in this regard, think about section 51, subsection 31. Think about that constitutional guarantee that the Commonwealth will pay compensation on just terms, but only where there is a deprivation or a removal of property. And that then sparks the question of, what do we mean by property? Easy? So just have an answer structured for yourself. Then think about other Commonwealth powers. I've only mentioned section 51, but there are others. Section 90, section 92, section 52, and section 109. If you're watching this or video later, just stop now, go and have a look at those sections. If you're attending live, just make a note of that, because I'd really like you to have those sections ready to go in terms of arguing a position or providing an essay response to do with, largely, the Commonwealth lawmaking powers. Okay, what's the star of the show when it comes to Commonwealth laws? Well, I think we all know the answer to that. It's the EPBCA. So in 1999, the Commonwealth enacted the Environment Protection and Biodiversity Conservation Act, a watershed piece of legislation. It provided information about how the government joined with states and territories to provide for a national scheme of protection to the environment and biodiversity conservation. So if you're looking at some idea of what it is that is important in the EPBCA, have a look at section 3. It's the objects clause. That's the starting point. Beyond that, have a look at section 3A, which deals with ecologically sustainable development, and then go on to think about national environmental significance or matters of national environmental significance, NMES. And you'll see them listed: World Heritage, National Heritage, Ramsar wetlands, threatened species, nuclear actions, Commonwealth marine areas, Great Barrier Reef Marine Park, and water resources from coal seam gas. So that's the next thing you need to do when you're looking at the EPBCA and getting an idea of the extent to which that legislation is effective. Also, think about the processes that are referred to in the EPBCA. As a tip, I'd ask you to go and look at section 523, which talks about defining an action as a project or a development or an undertaking or an activity or an alteration of any of those things. So when we talk about an action under the EPBCA, it's pretty broad. Then, once you've considered what an action is, think about what a controlled action is. Have a look at section 67. Have a look at section 74, capital A, which provides for penalties on breach. And once you've got those key concepts in mind, the next thing to do is think about a referrals process. Referrals means that when a person or an organisation contemplates taking what is a controlled action, that person or that organisation must refer the proposal to the Federal Minister for a decision as to whether in fact it is a controlled action. Now the state can refer it to the Minister as well at a federal level. In other words, the Act provides that it's up to the proponent to refer a proposed action to the Federal Minister at an early stage. Have a look at section 74 of the Act, which provides for the Commonwealth Minister having an opportunity to invite state ministers to make comment. So, something is referred to the Federal Minister what does the federal minister do? Well, there are some published guidelines in that regard, and the question that the minister must undertake is this: is there significant impact as a result of this proposal? Now, I mentioned that it's for the minister to determine that. It's really subjective. It's not objective in the usual manner. Have a look at sections 74 cap B and section 75, which provides for that subjective determination of the minister. And I've mentioned that there has to be significant impact. Well, impact is defined. Have a look at section 527 cap E. But it's not just completely lawless. It's not just a complete situation where the minister can do whatever he or she wants to do when deciding whether a proposed action is a controlled action or not. The minister must apply the correct test, and in that regard must follow published guidelines. I'm going to share the screen for a moment and show you what I mean by that in a practical sense. So the Australian Government Department of Environment and Energy provides a guide to undertaking strategic assessments, and the purpose is to determine whether or not the action in question is going to be determined as a controlled action or not, whether it has significant impact or not. Now, that might be relevant to the second assessment that you need to consider, which does deal with the interplay of the federal government, the federal minister, and also the state tests as well. If you're looking for a case which deals with the question as whether the minister adopted the correct test in making his or her determination, have a look at the Nathan Dam case, which is reported in the Minister for Environment and Heritage against Queensland Conservation Council, 2004-134 LG-ERA 272. The minister said the dam is not a threat of significant impact to the Great Barrier Reef. The court held that the minister had adopted the wrong test and had considered the term impact too narrowly. Now, that dam proposal has actually been considered by the Queensland government as well as the federal minister. Just to give you an update on what's happened with that Nathan Dam case, let's have a look at the Coordinator General's website in relation to it, and you'll see there for the Department of State Development for Queensland Government, from the Coordinator General's website, an overview of the Nathan Dam project, its EIA status, which is approved with conditions, and then a history of the process for the environmental impact statement. Most recently, on the 13th of July this year, the Commonwealth Minister approved it as a controlled action, subject to conditions, and that followed on from a Coordinator General's evaluation report on the EIS. So the Coordinator General is state, and the Commonwealth Minister, of course, is federal. Now, the reason I'm showing you this is that it helps to bring these things to life. You know, it's all a bit dull just listening to me talk about these things. It's as good as the text is, it's a little bit dull just reading about these things. So I really want you to go and have a look at the website and get a feel for what this means in practice. What actually does an environmental impact statement look like? What are the terms of reference for the development of the EIS? How does a coordinated project come into existence? What is the gazettal process? You don't have to go into a lot of detail, but it does provide you with an opportunity to see these things in practice, hopefully bring it to life. And that's the intention of the second assessment piece, where you need to actually deal with these things. Okay, and there's a note here about having to work on that. So thank you, Kim, for that comment. All right, so we have, if you like, at the Commonwealth level, the roles attributed to the federal minister. We have the impact of the EPBCA. All of this comes about as a result of the Intergovernmental Agreement on the Environment, the IGAE, and the manner in which the processes were streamlined. When you're reading about these things, when you see something about bilateral agreements, I want you to take particular note, because that's the mechanism by which there is an avoidance of duplication between state and federal operations and consideration of the EIS. So the Minister has considerable power under the Act, and in that regard, just to wrap up, have a look at sections 87 and 130 and 134 of the EPBCA. And that should do us for tonight. All right, any questions before we wrap up? All good? Okay. Well, thank you very much. I'll end the meeting now, and I'll see you next week. Is a break. The week after that, which is week 5, so 2 weeks from tonight is week 5, there will be no live lecture. I'm pre-recording some material which I will post on Moodle. So I'll see you live in week 6, which will be 3 weeks from tonight. All the best, and we'll see you then.